Now, the South African National Editors Forum, Sanef, says Zuma's private prosecution of News 24 journalist Karyn Maughan is an abuse of process and blatant intimidation of a journalist. Sanef has applied to the KwaZulu-Natal High Court in Pietermaritzburg to be admitted as a friend of the court. It's in arguing why Sanef can assist the court in determining the matter. Advocate Max du Plessis referred to the online vitriol and threats that Maughan has received. The former president has launched a private prosecution of advocate Billy Downer and Maughan for allegedly publicising his medical records. The Helen Suzman Foundation, the Campaign for Free Expression and Media Monitoring Africa are also applying to be admitted as friends of the court.
Let's stay with developing news around this story and, of course, the breaking news you're seeing on your screen right now, and speak to Mpumelelo Zikalala, a legal analyst. Kuzen, thank you so much for your time this afternoon. Breaking news, let's start with that. The Constitutional Court unanimously dismissing the former president's last attempt to have prosecutor Billy Downer recused through a special plea process. Is this the last hurdle?
Let's call it the second last, depending on whether the president is going to apply either for a variation of the order or rescinding the orders that have been issued by the Court. But even then, the chances of that particular application being successful are going to be small to nil. Basically, the Court is saying that we are choosing to stick with the horrid case and the principle which was developed of saying that charging to prosecute is only on administrative issues and nothing else. When it comes to the conduct of the prosecutor, there are other avenues that are there. Those are the conducts that you must follow, but we are not going to listen to this particular matter because for now we think it's done and dusted.
So basically, those who are hoping that the arms deal trial can finally go ahead may have to hold their horses.
Yes, they may, on two reasons. Firstly, we are approaching the 15th of December, but to the 15th of Jan, in which we would consider it as more or less a closing down a holiday period for the courts. So I don't think any matter is going to be considered between those periods. Secondly, there's still that variation of the order that will be issued by the Court that may be launched by the president. Or even the president may come back and say, you've dismissed my matter without me going to the Court and having to submit oral submissions. You may be persuaded once I've been able to do that. Please open the door and avenue for me so that I can be able to persuade. So it will be up to the Court to then say, are you going to be successful in doing that? Or the Court may come back and say, we are not going to listen to you. This matter is done and dusted for us. This is the order that we are sticking to, and we are dismissing your application.
How much of a bearing are the proceedings that are taking place this afternoon on this particular trial going ahead as well? Because he is seeking a private prosecution here. And can we see an argument perhaps of saying, let this matter wrap up before we then try to see if we can then proceed to trial? Do these arguments have a bearing on one another?
Not necessarily, even though it may paint a very bad light of the NPA, where you have a prosecutor has been privately prosecuted by the same accused, and yet that particular accused is then being prosecuted by the prosecutor that has problems. You may find that a bit of discomfort in the manner in which those applications should go. But the courts have been very clear in terms of saying, for the Zuma versus Advocate Billy Downer matter, which is currently being heard, the process would be you are innocent until proven guilty, and the vice versa would then apply when the former president is in the dock. So you may see these matters going parallel, and depending on which one finishes first, then you can come back and say, but you are conducting your trial in a manner which is not really fair. It does, though, hinge or maybe provide a certain advantage to the former president, because he can then come back and say on the unfairness of the trial, which should be in contravention of Section 35 for Constitution, then say, by you allowing this prosecutor, which was tainted, who I was prosecuting at the time of my trial, you have then allowed me to have a mistrial. You have then allowed me to suffer in that my rights in terms of Section 35 have been infringed. Had you allowed him or forced him to move out of this particular matter, we'd be singing a different tune now. Also, by him being part and parcel of this trial, the fairness of the whole process has been tainted. This matter has not been handled in a fair manner. We are dealing here with a person who has a personal vendetta against me and is not merely doing this job simply because he wants to ensure that the work of the NPA is done to the team. So on that basis, can you please consider the unfairness of this particular trial, and it will be part and parcel of the things in which I'm going to submit at the end of the trial as to why I should not be found guilty or why that matter should be dismissed due to it in contravention of Section 35.
Yeah, and that could, as you say, could further complicate matters. But let's also look at this case that's currently sitting in the Pietermaritzburg High Court. I mean, we've been listening to arguments throughout the course of the day, and the Helen Suzman Foundation, among others, wanting to be admitted as the friends of the court. And they're citing, specific aspects which they argue that is an abuse of court processes. But the former president dismissing this as ludicrous, saying that, their position in this one is nonsensical, particularly when it comes to how they view it as an assault on prosecutorial independence. How strong are these arguments that have been presented on both sides? Do you see them coming in as friends of the court?
Well, depending on how the court is going to view this process, let's look and identify what is a friend of the court. Is someone who's going to assist the court in instances or in certain subject matters in which the court is not vested in those particular subjects. So don't come in there as an interested or prospective litigant that has a specific outcome that they would want at the end of the day to achieve. So if you then come in that particular sense, that means you're not assisting the court, you're simply arguing the matter in favor of one of the applicants or one of the litigants that are there. Now, that's not what the friends of the court ought to be, and they're not really needed if they're going to come with that particular perspective. If the reasoning had been, we want to show the court how the freedom of media should be, freedom of speech should be, the way in which the media industry works, and the type of instances and how reporters do their jobs and journalists do their jobs, then I would have understood maybe and would have taken them into account, and maybe the courts would have taken them into account in terms of saying, let's say what you have to say, you're going to add value in our administration or presiding powers or decision-making processes. But now what you are doing as the applicants, you are fighting a case for one of your own, you are fighting a case for one of the litigants which are here, and you cannot be branded or regarded as a friend of the court if that's the intention or your intention in terms of making this particular application. Now, on the opposing side, on the side of the former president, I think that should have been the argument in which they would have came in with, and they have said, we are not really looking here to be a friends of the court, we are looking to be a litigant, an active one who's going to take sides, and that's not the way in which things are done in this particular court. The presiding officer who's sitting there is well equipped, has researchers, there's previous case law, and can simply decide this case without being assisted. There's no need for any friends to be there of the court because this is a straightforward matter. It only needs adjudication.
I suppose then it's no surprise that part of the former president's arguments is that the National Prosecuting Authority does not need, and I quote, the guiding hand of misguided busybodies and celebrity litigants. I suppose then this is what they're hitting at now, to say you are not coming to assist, but you're simply looking for a specific outcome, as you are saying.
Definitely, especially when you are dealing with the contravention of certain legislation. Common law, maybe I would have listened here and there in terms of, because we haven't really developed a certain common law in certain instances. There are still pockets and lacunas which are lacking in our common law. However, when the law is legislated, it's a different story. You have the Criminal Procedure Act, which is alleged to have been contravened, and it is clear as to how those particular contraventions are supposed to take place and instances that are there. So basically meaning, here you are dealing with an allegation or a crime which is technical in nature. All the elements have to be available before you pronounce a person as guilty. So what is the friend of the court going to do when certain elements simply merely have to exist and then the person is found guilty at the end of the day? So they're quite correct in terms of saying you are an interested party, you come here as a litigant. You do not come here as a friend of the court. The friend of the court has to be independent, they have to be objective, they have to state facts, they have to state things as they are without taking any other side, to such an extent that even if in their arguments, if there are arguments for and against of each of the litigants that are there, that's exactly what they need to do, because all they are there to do is to be the voice of reason for the court and say to them, we are going to provide you with the resources that you might have not have due to maybe time or resource constraints, but we are going to assist you as the friends of the court. So if you come in there as a litigant, then you don't qualify to be a friend of the court.
All right, let's see then what the court then says, if they are going to be admitted as the friend of the court, and see then what becomes of this one. But thank you so much for that analysis. That is Mpumelelo Zikalala, a legal analyst.